Hello friends, in the series on the income tax cases, today we will discuss an issue which is based on the right of personal hearing of the assessee. It has been seen in the assessment proceedings and in the appellate proceedings at the CIT appeal level that the revenue is not very much interested in giving the personal hearing to the assessee, and they try to find every way in which the assessee can be denied the personal hearing. Many of the times it happens that the date is fixed for the personal hearing, and when the assessee opts for the personal hearing and the time is scheduled for that, sometimes it happens that the personal hearing is not actually effectuated and the assessment orders are passed on the same day or the next day by saying that the assessee didn't participated in the personal hearing, whether it was the fault of the assessee because of technical reasons or on the part of the revenue. But in neither of the case it has been seen that when the personal hearing could not be done for any of the reason, whether the assessee could not attend, whether there were some technical glitches of the internet, whether on the part of the revenue or the assessee, the department never comes forward on his own and say that this personal hearing could not be done, so the another date is fixed. So this type of attitude on the revenue is not good for the proper administration of the whole assessment proceedings. In the present case, a limited issue was before the Allahabad High Court that whether the assessee should be given personal hearing even if not requested by the assessee before passing an adverse order against the assessee. This issue has been taken in the case of Satish, Kumar, Bansal, HUF versus National Faceless Assessment Center and another, and this case has been reported in 464 ITR at page number 578, and the date of the judgment is 26th April 2024. As always know that for personal hearing there are two sections, section 144B subsection 6 clause 7 and section 144B subsection 6 clause 8. In the present case the additions were made, but the opportunity of personal hearing was not given to the assessee and the assessee has not requested for that. The assessee was challenging the assessment order on the ground that because adverse view has been taken against me, so it was the mandatory requirement before passing the adverse assessment order against me that an opportunity of personal hearing should be given to me, but the revenue was contesting that the assessee has not requested, so it is not required as per section 144B subsection 6. When this matter was heard by Bombay High Court, the Bombay High Court said that there is no denying the fact that the assessment proceedings is a process of evaluating the disputed facts and disputed law. The court said that whatever the written submissions are given by the assessee, that may be received differently by the assessing officer on a simple ex-parte reading. The court said that personal hearing is important and near about mandatory requirement for completing the assessment proceedings, and personal hearing is also essential to pass a just and proper judicial and quasi-judicial order. Personal hearing is important to preserve the faith of the assessee in adjudicating authorities, and the court said that if any addition is made, the reasons should be conveyed to the assessee that why the additions have been made, because only then the assessee can take the call that whether to pay the taxes on those additions or to contest those additions. The court said that if the personal hearing is not given to the assessee and the matter came to the CIT, then it is a tried law that the CIT cannot remit the matter back to the assessee. So even if the CIT appeal gives the personal hearing in spite of AO, then this does not take away the right of the assessee of personal hearing at the time of the assessing officer, because that right cannot be replaced by the CIT appeal. The court said that if the additions are being made by not accepting the written submissions of the assessee, then it is mandatory on the part of the assessing officer to grant an effective personal hearing to the assessee before completing the assessment. At the end of this video, once again I am repeating the name of the case. The name of the case is Satish Kumar Bansal HUF versus National Faceless Assessment Center and another. And this case has been reported in 464 ITR at page number 578. And the matter has been decided by Allahabad High Court, and the date of the judgment is 26th April 2024. Thank you, friends.